Good evening, everyone. Um, First of all, an apology for not being able to connect on Saturday and postponing it to today. Straight going into the update for this month of September. Um, we don't have any amendments or ordinances for this month, but there are quite a few circulars and notifications that have come. We'll have a quick look at them. The ESI Corporation has extended the provisions to contractual and casual employees of municipal corporations, municipal councils, and urban bodies. So many contractors were not paying, especially in Tamil Nadu, Orissa. They have taken note of this and they have extended it. This is specific to the corporations because the corporations are exempt, but not the contract employees and casual employees. So they specifically extended it to them. The minimum rates of wages for building operations in Puducherry has been revised quite considerably. The amount of increase is quite considerable. Going again with the PF for higher pension pursuant to the Supreme Court orders, the EPFO once again extended the time for uploading wage details for higher wages by 3 months. So those who have already opted, they have got another 3 months to upload the wage details. There is one more SOP as well that has been circulated on joint declaration saying because their IT tool is not ready, they have said that hard copies can be taken and what is to be done and what is required, because at the moment quite a few of the applications are being rejected for want of data. So, or the data that has been given by the employer is incorrect. They have been rejecting it. So you would need to verify with the SOP and see what needs to be done. Sorry, I'm just getting a comment saying that my voice is not audible. Let me just check on that. I hope that you're able to hear me better now. I'm just, give me a minute, please. I hope you're able to hear me better now. So going forward, the central government for various industries and categories has increased the DNS allowance. Again, not much applicable to private employer, but it is applicable across central government organizations. Every year, the Bengal government does publish guidelines with regard to bonus, more because they take the festival of Dashera festival to be a very serious occasion there, and therefore they have requested for ensuring payment of bonus by 6th of October, and they have given out. This notification or guidelines comes across in West Bengal every year periodically, and this year also they have issued a circular to that effect. In the electronic equipment Kerala, again, there has been an increase in revision with the electronic equipments and home appliance and software system industry. So once again, you find that wages ranges from 14,000 to 18,000. That's the kind of an increase we are looking at. UP government, like Karnataka, Tamil Nadu, has exempted IT and IT-enabled services from the provisions of the Shops and Establishments Act, the UP Shops and Establishments Act. ESI Corporation, with regard to the seeding, has also made certain changes to their process, and they've made it on a voluntary basis for the present. Again, under the ESI Act, the period for the scheme has been enhanced for, increased for another 2 years till 36/24. The scheme has been increased. In the quiz section for this month, Sorry, I'm rushing a bit because there are quite a few slides for this month. Uh, the question is whether an apprentice under the Apprenticeship Act is liable to be covered under the Provident Fund Act. We have two interesting enactments. One in the global segment is the UK, where they have introduced a new enactment called the Predictable Terms and Conditions Act. This is more with regard to the contract labor kind of persons, on whether they can seek what is the kind of prediction or how much amount, how many days they are required to work. They need certain clarities. They could ask the employer for such clarity twice in a year. And in Spain, they have recognized that the migrant workmen are much more, and therefore they have tried to introduce for domestic workers a kind of an insurance or security benefits, unemployment security benefits, even for migrant workmen. I'm sorry, a domestic workmen, primarily because recognizing the fact that there's a lot of migrant women who are involved in this domestic work sector. An interesting fact we thought we'll share is where there was just one biscuit missing. Out of a packet of 16, there were 15 biscuits, and an Indian company has been asked to pay 1 lakh to a man for having found that there was one biscuit less in a packet. This is a case arising from the Bombay High Court. It's a question of, you're aware, under ID Act 33C2 of the ID Act is a computation petition. So where there is a pre-existing right for workmen to claim some monetary amount from the employer, he can file a 33C2 petition. But in this case, the management claimed that there was no employer-employee relationship. The question then was whether such a question can be adjudicated in a petition under section 33C2. The Supreme Court, following earlier decisions, has reiterated that such a question cannot be gone into in a petition under section 33 capital C2. The next case is more on a service law of where persons were working on temporary basis and thereafter they were regularized. Whether the temporary period can be reckoned for pension or not was a question, and the Supreme Court has held that only the period they work as regular employees of the Doordarshan Prasar Bharati Corporation alone can be reckoned for pension. The answer to the quiz question is no, apprentices are not required to be covered under the EPF Act. This is a question under the POSH Act on whether two complaints were there within the 90 days provided in section 11.4 of the Act, whether it has to be completed within that, or can the delay be condoned. And the court has taken a more liberal view to say that the time frame can be looked at to in a more liberal manner. This is the complaint chart for the month. We are looking at the data protection and employment laws, how they are related in the knowledge corner for this month, because we have this new enactment in India, the Digital Personal Data Protection Act 2023, where it flows is from the case of KS Puttaswamy, which is linked to Aadhaar. And the Supreme Court said the right to privacy is a fundamental right under this judgment. And from there, this enactment started to flow. And that's where we have the DPDP of 2023. And it has also been to be notified. Before going into the provisions of the Act, to impress upon you as to what could be the serious consequences, we thought it will be more appropriate to put the penalties in this Act at the first instance, even before going into what is the Act about, because the penalties could be up to 250 crores. So there's a substantial penalty amount that can come on companies. And we are today here dealing only on the employment law aspect of it. We are not going to be looking at the entire Act. We would be looking at the provisions of the Act, but how It is more related to the employment and the company. So what is looked into in the Act broadly is four parameters. You have a data fiduciary, which is mostly the employer. And then there could be significant data fiduciary as per the Act, which the government is to notify. It is more the larger corporations, for instance, Facebook or WhatsApp, all these larger companies which collect data, they could be termed as a fiduciary. Data principle, for instance, in employment law concept, it is your worker or your employee from whom you are trying to. And in certain cases, the data protection officer is also required to be appointed by the data fiduciary. So this act is primarily for personal data. It's not for any data. The personal data could be collected in a digital form, or it could be collected initially even in a hard copy and thereafter digitalized. So both will be applicable. Even if the data is to be showed offshore, not in India, outside India also, the act would be applicable. So primarily, what are the rights, duties, and obligations is what we see. So we have the purpose limitation and the collection limitation as to what is the purpose, the specific intent for which you are collecting the data. Even if data that you collect today is with a particular purpose, you cannot thereafter use it for a different purpose without the consent of the person who is sharing the data. That is the data principle. So you would need to take consent in the manner in which is required under the Act, specifying the purpose for which the data is being collected. The person who is giving you the consent can withdraw the consent. There should be a provision for him to withdraw the consent. There should also be a grievance redressal mechanism which should be provided. So these are the larger aspects of the Act. So as an employer, whenever you collect any personal data of an employee, you would need to collect his consent for collecting as well as storing that data in digital format. The employee can at any point of time withdraw the consent for you to store the digital data. Questions may arise. I'm required to do this for statutory purposes like Provident Fund, ESI, Factories Act. Those are exempt. So those data which are required for statutory complaints, that's not covered and that's exempt. Whenever a consent is obtained, it should be very free. There should be no question about it. It should be specific reason for which it is done. There should be proof that the employee has been informed about his rights and for what you have collected the information in an unconditional and unambiguous manner. So these are things that you would need to be aware of. So consent is going to be a huge issue. You would need to collect consent. As I said, only for employment purposes. In other words, for statutory purposes. If you're going to collect some data, then it is fine. But all other purposes, you would need to take the consent of the employee. For instance, medical records if you're storing of the employee, or family details you're storing beyond statutory purposes, then you would need to ensure that the data is safe and you are collecting it with consent. So for instance, for the purposes of insurance policy, you have a group medical insurance, you have a group personal accident policy. These are all not statutory. These are benefits which you are extending beyond the scope of the Act or any statute. When you do such collect data for such kind of actions on your part, you would need to ensure compliance with the provisions of this Act. So these are primarily the provisions of the general understanding of the Act. We will share you the PPT on this aspect. We will also try to keep you posted on what is required. We would be sharing in our LinkedIn as to what is required. The other stuff as to how a data fiduciary or significant data fiduciary are not more employment law related. Therefore, we are not dwelling much into that. So as a data principle, that is your employees, they are the data principles. They should have the right to access their information. They can correct the data at any point of time. They should be able to either ask you to erase it or ask you to their consent they can withdraw. There should be a grievance redressal system for them. And then they could nominate somebody as well. So, for instance, if your employee were to die at some point of time, his legal hands can come and say, please erase the data. So, to that extent, the Act has taken care of various things. And there are also the data principles are also given certain things like they shouldn't be giving false grievance or false information, and whatever they do should also be compliant with the requirements of the Act. So there is an enforcement body called the Data Protection Board, which is the one that has been given the power to levy penalties up to 250 crores. And it's got very wide powers to do. And if you're for any reason unhappy with it, you then have an appellate remedy to the Telecom Dispute Settlement and Appellate Tribunal. So these are the broad, we have just given you a bird's eye view of the Act. We'd be more than glad to help you more on with regard to the compliance of the provisions of this Act. Thank you. Please do join us on 28th October at 4 p.m. We once again apologize for not being able to connect with you on Saturday. Thank you.